This is Juan Arias coming to you live from Fort Lauderdale, Florida. Welcome to my webinar on referral fees don't exist in Florida. As you all know, we have participation fees, and this webinar is designed to go over some of the basic concepts behind participation fees in Florida. I am an ethics attorney. I've been practicing in the ethics area for 14 years. I've been an attorney 24 years. And part of my practice is to provide consulting for retained clients throughout the state of Florida. I also represent students, law students, when they're trying to get into the bar. I represent also healthcare professionals, nurses, psychologists before their boards. So I keep pretty busy, and I always like to share some of what I know with other attorneys across the state. So I'm here for you. If you ever need any help with a bar complaint or consulting, you can reach me at my contacts here on my Facebook page. So let's talk about referral fees, so-called referral fees. In Florida, we have participation fees. So where does the whole thing of 25% referral fee comes from? It's probably a misunderstanding of the rules, and you'll see that under 10 minutes how that could have happened. But in reality, in Florida, we have participation fees. That means that you are, as an attorney, on the hook for the representation of any client that you have referred to somebody else, and you expect to make money out of that referral. So you are not off the hook in Florida. There are two ways where you can split or share a fee with another attorney or in an attorney in another law firm. And that is one, look at Rule 4-1.5G. One method is to divide the work proportionally. So you can get paid proportionally if you refer a case out. Also, the second way under also 4-1.5G is by assuming responsibility for the case, and two, by agreeing to be available to the client. So that's the second way where you can receive a fee for referring a case to another attorney or to another law firm. Now, this is in general terms, how referral fees work. If you have a contingency contract, and I'm not talking about PI cases yet, I'm talking about in general contingency contract, then there are other provisions that you need to observe, and in particular you need to look at 4-1.5G and F, because F2 actually tells you that when you have a contingency case, it could be any type of contingency case, not only PI cases, you need to have two things. One, the referral and fees, the agreement needs to be in writing. Two, the client must consent to the splitting of those fees, of those referral fees. And three, the client must sign the contract, and also the referring attorney who is receiving potential fees. So for contingencies, you need to have those three things. Once again, in writing, approved by the client, and you also have to sign the contract. All the attorneys receiving fees. That's for contingency cases. And again, this is not for PI. I'm talking about contingency cases in general terms. Now, for contingency cases that involve personal injury cases, wrongful death, or property damage, then there are more requirements. So what are those? Well, you probably have heard about them, because that's what people tend to think of when they say, I want a 25 referral fee. And that is the provision for contingency cases that deal with PI, personal injury, property damage, and wrongful death, is that division of 75-25. It's preset by the rules of ethics, and that's under 4-1.5FD. And that means that the main attorney doing work gets 75, And normally the referring attorney, the one that is sending that case to that firm or law firm, or a lawyer making 75%, can get 25%. So that's a 75-25. Referring attorney 25, and the actual attorney doing all the work 75. In PI contingency cases, wrongful death cases, and property damage cases. So that's where that 75-25 comes out, but it's only required in these three type of cases. So it's a misunderstanding that attorneys have out there, that they are entitled to a 25% referral fee in all cases, and it's not true. It's actually only limited to that group of three cases: the PI, wrongful death, and property damage. So that's the first thing that we have clarified here, that always confuses attorneys. The other thing that you got to look under contingency for PI and wrongful death cases is that the secondary lawyer could ask for a higher fee, and if in fact that secondary lawyer is doing more work than the 25% required under the rule, you can go to the court. You can seek court permission to make a division with that other attorney that is fair in that particular case. So if you're doing 40% of the work, or if you're doing 50% of the work, then you could get a 50-50 split, but you got to go to the court and get permission for that. So those are unique circumstances and only apply to PI cases that are contingency cases, property damage, and wrongful death. So first thing, the 25% referral fee that we all talk about in all cases doesn't exist. It's actually a participation fee, and there's no 25% unless you're talking about a contingency case of these three areas. That's it. So the question that would follow is, what if I have a criminal case? What if I have a family case that you want to refer out? There is no requirement of a 25. You could get a 50% referral fee. You could get a 30% referral fee. Yeah, there's nothing out there that says that in those cases you got to get 25. So the answer is very clear. Yes, you can get a referral fee from any type of case that you refer out. That's the bottom line. It doesn't matter what type of case it is. Another thing I wanted to mention is that insofar as you agree in any case to take responsibility for the case and be available to the client, you could get a participation fee. As I'm being using referral fees because that's what we all call it, but it's really a participation fee. But what you always have to remember, and this is the key difference, what's the big deal between participation and a referral fee? In a participation fee, your license is on the line. Your malpractice is on the line. So if you refer out a family law case because you don't do family law, and the attorney that you refer the case to, if you follow the rule, you notify the client, put it in writing, everybody's kosher on it, and then that attorney that you referred it to commits malpractice, the client can go after you. That's why you're always on the hook. That's why the proper term is a participation fee, not a referral fee. So you are always responsible. So what is the take away from this quick webinar under 10 minutes? You got to have the consent of the client. There are some attorneys that refer cases out and they don't really tell the client that somebody else is working it, and that's really not appropriate. So make sure that the client is a participant of this, and again, put it in writing. There's nothing wrong with having it in writing. This has been the do's and don'ts on referral fees, which are really participation fees. Remember to review the rules always, now and then, when you're doing things that you're not used to do. When you're going to refer a case out, make sure you review 4-1.5. It's not a long rule, especially the initial portion that tells you what is expected. But put it in writing. Make sure that it's all in writing. Very important point. One important point on closing statements. Yes, If you refer a case out and you are receiving a participation fee on a contingency case, you should all the lawyers receiving fees need to sign the closing statement. And I know this is a frustration for many attorneys out there because it adds steps to the closing statement, but all attorneys receiving a referral fee, participation fee from a contingency case should, must, are supposed to sign the closing statements. Well, it has been my pleasure. Remember that I have an upcoming webinar with the Broward County Bar Association and 13 other bar associations on conflict of interest. It's going to be on September 17 at noon. We're going to review the 8 rules of conflicts of interest and waivers of conflict. So see you September 17. Take care. Thank you for dialing in, and I'll see you soon again on a webinar. Bye-bye. Be safe.